Hello, welcome. My name is Octavio Ferraz. I am the co-director of the King's College London Transnational Law Institute, and it's my great pleasure to talk today to one of my colleagues, Professor Parosha Chandran, who has just won a very important case on modern slavery and human trafficking in the European Court of Human Rights in Strasbourg. And what a great pleasure to start this series with Professor Parosha Chandran, especially at such an important moment of her career. Professor Chandran, who is a barrister based at Wampum Court in London, has done invaluable work in the field of modern slavery and has just achieved what is perhaps the highest possible judicial recognition with an unanimous judgment of the European Court of Human Rights, which sets a precedent that will benefit not only the claimant in that case, which she represented in court, but many more victims of human trafficking in the UK and beyond. So we'll talk about this case, of course, today, but also more broadly about Professor Chandran's trajectory so far and her future plans. So without further ado, let me invite Professor Parosha Chandran to start telling us, in her own words, what this very recent case decided only a few days ago by the European Court of Human Rights is all about and why it is so important. Parosha, thank you so much for being here with us today. So over to you. Well, what happened in that incredible case?
So Octavio, firstly, thank you very much for that very warm welcome and congratulations on all the work of your department. It's a great honor, actually, in my career to be a member of the Transnational Law Institute at V.C.L and the Dickson Poon School of Law, something that I came to later on in my career, which we'll discuss later. So yeah, the case. In short, in 2011, so that's a decade ago, I brought a case before the British courts with a colleague of mine to try to overturn the criminal conviction of a young boy from Vietnam who had been trafficked into a cannabis factory by organized criminal network. The windows were bricked up, the door was bolted from the outside, and the drugs, when the boy and others were found by the police, was in the region of a value between £500,000 and £1 million of value. The only reason that the boys were found, the children were found, was that a vehicle had ram-raided and crashed a wall of the building, probably by burglars wanting to steal the drugs. But people in the locality called the police and the police came. Now, when the police arrived back in 2009, as I said, I brought the case in 2011 when I came upon it, but other lawyers represented in the matter before me wrongly represented him, may I say. The police took him and arrested him for cannabis cultivation, and he was prosecuted by the Crown Prosecution Service, and he was convicted by a criminal court. He was told by his barristers and solicitors to plead guilty to cannabis cultivation, and he was given an 18-month detention and training order, which was half of the time to spend in child detention, kind of child prison, and half the time to spend in community service. So I came across his case with colleagues of mine who were working in an NGO. And they told me about him, that he was coming out of prison and he was, you know, probably somebody who hadn't been convicted, but they didn't know what to do about it. So I brought a case in the Court of Appeal in the United Kingdom to try to overturn his criminal conviction, arguing that there were legal obligations on the UK under the Council of Europe Convention on Action Against Trafficking in Human Beings to protect and not punish him for criminal activities that occurred as a direct consequence of his trafficking. But actually the court was totally resistant to applying the non-punishment principle in his case. I was shocked actually, because many years earlier in 2008, I had brought the first non-punishment case in the UK, representing a Nigerian girl who'd been trafficked into the UK for sexual exploitation. And she was caught at Dover Docks, our port, trying to get over to France on a ferry using a fake document because she was trying to escape the trafficker. Again, with a good colleague, I brought a case in the Court of Appeal, Criminal Division, to overturn her conviction based on the non-punishment principle, and it was absolutely successful and set one of the world's leading precedents on non-punishment at the time. But I didn't really realize, and maybe you could call me naive, but I'd been a barrister for a pretty long time by the time I brought A.N.'s case in 2011, that in fact there was a resistance because of the type of exploitation. Because it was drugs, it was considered that there should really be limits on the protection for victims of trafficking. Now, I couldn't stand by and have that happen because it isn't the choice of the victim as to how they're exploited. It is the decision of the trafficker. And the trafficker is profiting from the hand of the victim when it comes to these cases of criminal exploitation. So I brought that case. It was rejected by the Court of Appeal. The conviction was maintained. The court decided that he hadn't been forced into labor enough, because they decided you have to have a period of time and didn't specify what it was, even though he had been in there for some time. They said that he wasn't a victim of trafficking as a credible victim, even though they didn't apply the definition of human trafficking to his case, which simply requires recruitment of a child for the purpose of exploitation. There was also a formal decision by our national referral system in the UK, he had been trafficked, and they also rejected that. So it was utterly inconceivable to me that this child couldn't receive protection in the UK. And exhausting domestic remedies meant trying to get to the Supreme Court. The Court of Appeal stood in the way, refused us leave to go. And so I lodged it in Strasbourg in 2012. And that's where it stayed until 2021, this year. What the court found was that the prosecutor and the court had no good reason to dispute the identification of human trafficking that had been reached by the formal body in the UK, which was actually the Home Office, a government department, and that there was a need for a diversion from the criminal prosecution of anyone who might be a suspected victim of trafficking. And all the hallmarks were there when he was arrested that really shed light on that. He was 16 at the time of his detection by the police. So they found very unanimous findings, very grave findings against the UK, a breach of Article 4, which is the prohibition on slavery, servitude, forced labour and prohibition of trafficking as well, following the Rantsev and Cyprus case of 2010. And they also found failure of positive obligations on the state to have protected him. And they found a breach of Article 6, fair trial guarantees too. A novel point about this case, or a couple, is one, it was the first case by any international court or tribunal in the world, or a regional one, on the application of the non-punishment principle. And number two, I brought a very strong compensation claim on behalf of N. What I argued was that he should be entitled to compensation by the state for the pain and suffering that he had received and for the wrongful prosecution that had occurred when he was actually a victim. I pleaded it at a high level for the ECHR, which is used to just giving very small levels of compensation or none at all, finding that a violation against the country can be just satisfaction enough. I pleaded it at 75,000 euros. The court ordered 25,000 euros, which was less than we had hoped for, but it is actually the greatest award of damages in the history of the European Court of Human Rights on a human trafficking case. And so that sends a very strong message out as well as to need to link compensation with justice and to make sure that states are aware that there will be very serious repercussions when it comes to them not getting it right in their home territories, and if cases have to go to Strasbourg.
Thank you. So many fascinating things about this case, which, as you just told us there, is unique. The first time that it happens anywhere around the world. One other thing that struck me was the unanimity of the decision. I teach European Court of Human Rights cases to my students in transnational human rights law every year. And it's really difficult to find a case in which there is at least not 2 or 3 judges dissenting from the decision. This one, but for a very small technical question, all the judges agreed on that, on the violations that you have mentioned. And the other thing that I thought was quite remarkable, especially for someone like me based in the UK, is how it doesn't show the legal and judicial systems in the UK in a very good light, right? It was not only the Crown Prosecution Service or the courts who didn't reach the right decision in this case, as you have already so well explained, but even the lawyers for the victims seem to be working like against them in the case here in the UK. Can you tell us a bit more about whether something needs to change with the system itself here for these things not to repeat in the future?
Yes, I think one of the fundamental failings of the UK was what happened back in 2009 when his name was N when I brought the domestic proceedings. In Strasbourg, his name initialized by the court as A.N, and the judgment is called V.C.L and A.N against the United Kingdom, because another case called V.C.L was linked to the case, and it was lodged one day before mine, and therefore it was listed first.
Yeah, and sorry to interrupt here, but I think it's important to tell the people who are watching this, you can Google that case and read the whole thing if you want. It's available in the website of the European Court.
Yes, and thank you, Octavio. So the question is very important. So what went wrong was that law enforcement had not been trained in how to safeguard victims of trafficking and to identify them upon detection in an obvious situation of exploitation of the human being. And so despite all the formal announcements of protection that might have been needed by 2009, because we actually acceded to the Council of Europe Trafficking Convention on the 1st of April, and this arrest took place shortly afterwards, there was nothing on the ground done to actually enable an implementation of a system of protection. Barristers and solicitors hadn't been trained either on how to identify victims of trafficking, on the trafficking definition, how to even think about how to apply it to cases before them of human beings who are in conditions of exploitation and may have been forced to do crimes that they were being prosecuted for. Neither had the prosecution nor the court. And I think this is a tension now coming to the prosecutor and the court that arises a lot, not just in the UK, but abroad. And it really has to come to an end now. Number one is, it is not for a victim of trafficking to be prosecuted and then to have to prove that they were a victim through the criminal proceedings that are being brought against them. In a way, you're requiring a victim to prove beyond reasonable doubt that they're a victim, and that is not acceptable or permissible under international law. A victim of trafficking is to be identified in procedures away from criminal prosecution of the person by trained identification experts, which ideally encompass NGOs as well as the state. The second thing is that prosecutors in the UK were able to exercise a discretion as to whether or not to apply non-punishment at the time that this case happened and until now. And so if you have a prosecutor who either doesn't know much about it or knows about it but doesn't want to apply it, maybe because of the form of exploitation, or decides against applying it wrongly and then still prosecutes, you don't have safeguards in the system unless the court can actually act as an instrument of justice to prevent the prosecution. And so that means that we really need to have judges properly trained as well. So these problems have been ongoing throughout the world. And indeed, as recently as last year, the then serving UN Special Rapporteur on Trafficking Against Persons asked me to assist her in a paper that she wanted to publish for all United Nations member states on the practical application of the non-punishment principle. But the ongoing prevalence of the punishment and prosecution of victims is still so real and alive that this April, the current UN Special Rapporteur on Trafficking Against Persons, Professor Siobhan Mullally from the Galway University, who's a leading expert in the field, invited me and other experts to join a group of experts under her leadership and to write a report for the Human Rights Council of the United Nations, which was then presented before the United Nations last month in June. So the non-punishment of principles is a critical feature of the combating of modern slavery and human trafficking in today's world. And the bottom line is that we have to protect victims from being punished for any unlawful acts they do as a direct consequence of their trafficking, because of the human rights ethos that has to lie behind the laws of every state when it comes to protecting people against trafficking and modern slavery. But also we have to recognize that in every single case where a victim of trafficking is prosecuted in this way, we are letting the trafficker go free. And they are using this device more and more in their trafficking strategies, in their business plans, knowing full well that if they use victims, it's the victims who will come to the attention of the authorities. It's the victims who will be prosecuted, they will be convicted, and they will go to prison. And in many cases, if they're international, they'll be deported. So we have to turn the corner on this. And this is why it is now at the highest level of the United Nations from last month, in order to gear about a positive change globally. And my case of A.N. against the United Kingdom is being very well used now by states. It's not an academic issue anymore as to what non-punishment means. It's
certainly, I think you've just explained there what I mentioned in the beginning, how this case will not only serve the actual victims who you represented in the court, but also go well beyond it. What about here in the UK? Are you hopeful that losing that specific case in Strasbourg court will make the government change things? Because we have some kind of sad precedents, like the prisoners' right to vote case, where the government dragged their feet for so many years. This case has already taken like almost 10 years, right, from the time you filed it in the court to the decision. And we know that this is an unfortunate problem of judicial systems. They are like overloaded with cases. And what about now on the government side in the UK? Do you think that there is any signs that they will take swift action to implement the outcome of the case?
It's a very good point that you're making here about how justice needs to be enforced in order for it to give rise to rights protection. So in this case, while Strasbourg delayed in adjudicating the case, and a lot of the delay for that was because the case which Strasbourg decided it wanted to link it to, which I didn't agree for it to be linked to, it wasn't a decision I was allowed to make. That got adjourned for a number of reasons, for domestic proceedings. So my case got lumped along with that delay, which has caused grave trauma for my client, which is why I'm making the point about delay. But what I'd like to say is this, that the UK government, once Strasbourg issued the chamber judgment, the UK government tried to appeal it. And they made an application for a referral to the Grand Chamber. And they had to do that within 3 months. The decision of Strasbourg was in February. They had to make the decision within 3 months, the UK government, whether or not they wanted to apply for referral to the Grand Chamber, which would be of 17 judges. And frankly, my position was, bring it on. We'll get a unanimous judgment of 17 judges. You want 17 instead of 7? I'm ready for it. But actually, the Strasbourg court rejected the British application of the government to have that referral to the Grand Chamber. There was no error of law that could be discerned, and no issue of concern that could undermine the findings. So I think now the British government has got to actually move its compass point towards this judgment and move about the mechanism of the criminal justice system so as to recognize the importance of these identification decisions reached by the NRM decision makers and the role of protecting, of the NRM protecting victims from prosecution, rather than just letting the victims get into the prosecution spindle and then being stuck there while they're not having any chance of recovering from the victimization they've already received, and then it's secondary re-victimization at the hands of the state. So I am hopeful, because if they don't get it right, then the Committee of Ministers will be looking at the execution of the judgment in a few months' time and seeing what has gone right and what has gone wrong. And I trust in Strasbourg.
Thank you. The other great thing about these cases, in my view, is that they highlight a particular human story behind like a huge problem, which in this case is modern slavery, but we could pick any human rights issue. There is always like the macro problem, which you read about in reports, and then there are the human stories behind them, which sometimes get forgotten because you read like that massive report from Amnesty International or Human Rights Watch or whatever, and there are like lots of data, statistics, thousands of people, hundreds of people, but you don't get the story of the victims. And in law cases, you do. So I do urge people to read these cases. You might think, oh, it's boring legal stuff. It's not. It's like really interesting human stories. So I was wondering, Parosha, if you could tell us a bit more about that human story behind it. We know already that this is in London, which might surprise some people. Oh, are there modern slaves going around London? What parts of London? Where did he come from? How did you get to know about that story in the first place to become the lawyer in that case?
Thank you. So in this case, he came from Vietnam to Britain with a human smuggler who was clearly linked to a human trafficking ring. And what had been happening is for a number of years, I had been, there was a highlight, a spotlight by NGOs in the UK on the fact that Vietnamese boys, predominantly between the ages of 14 and 17, were being brought into the UK for the commercial cultivation of cannabis by organized criminal networks. And that the police were always arresting them. They would be going to prison, and once they would be released, they would actually then go missing because they would call the traffickers and voluntarily be re-trafficked, because often the families of the boys would have been threatened by the traffickers, and the traffickers would have given instructions to children that if you're ever taken by the authorities, I expect you to come contact me and get straight back in touch with me, because you've got to work for me for X number of years before you're free. And if you don't, then I'll harm your family back in Vietnam. So it was such a concerning issue that we knew about in the communities of human rights here, but no one knew how to tackle it. For me, when it was an NGO who approached me and said, look, we've got this case, and a solicitor said, oh, we've got this potential case, will you have a look at it? And when I did so, the facts were so startling. He had been brought into the UK in the back of a lorry. He'd been released on the side of a road, and they said, look, your cousin lives at X address. You've never met her before, but you go and stay the night with her, and then you come back to this street corner tomorrow and someone's going to come and give you a job. So he goes and stays the night with his cousin, who's never met before. She and her husband are living there. And the next morning, he leaves that house and goes and stands on the street corner, and a man approaches him and says, I'll give you a job. So he goes with that man, a Vietnamese man. My client doesn't speak any English. And he's put in a house, residential house, for about a week, doesn't know what's going on. And then he is taken and put in this disused commercial factory that has been converted into a cannabis house, a cannabis factory. He's sleeping on a sheet on the floor. There's very, very toxic fumes from the drugs in the air. He's 16 years old, absolutely terrified. He knows that the property's guarded from the outside. As I said, the door is bolted from the outside. All the windows were bricked in, so bricked up, so no light could come in.
Do
And
we know where that house was? Sorry.
it was in South London.
South London, okay.
Yeah. And so then he wanted to escape, but he couldn't escape. And so on one occasion, he was allowed to go with a co-worker to the co-worker's family house. So a car came and picked them up and took them to the co-worker's house. And when he's there, he telephones the trafficker on the mobile phone that he'd been given and said, listen, I don't want to go back to the house. Please, can you let me go free? I'm frightened in there. And the trafficker said to him, we have made an investment in you, and you will go back there. And if you don't, I will find you and I will kill you and all of your family. So the boy then agreed to go back to the factory, and that's where he was when, as I say, the vehicle a few days later was ram-raided by a car trying to break the wall down, burglars trying to, ostensibly trying to steal the drugs when the neighbors were called. Now, what an important part of this story is that when my client was found in the garden area, some grassy area, he had his tears streaming with water because tear gas had been thrown in by the intruders. And there were 3 other boys with him when they were all arrested by the police. When the case came to me, there was no way for us to trace the other 3. So they always have been, for me, the missing children that I couldn't protect. So they would have been they all got convicted together, but then afterwards they would have been re-trafficked immediately. And God knows what happened to them after that. But thank God we managed to siphon our client into some protection. But to this day, and with this success, there's always sadness, which is that I haven't been able to protect everyone because I didn't know where they were. There was no way we could find them. They had gone already.
Yeah, but hopefully this case will highlight the issue and make the problem better for many others as well who will be able to rely on it. And I wanted to now talk a bit more about your other work, because you have had a remarkable career as a human rights barrister for 24 years now, if I'm not mistaken.
Yes.
You've already mentioned that you worked with the United Nations, with the Council of Europe, and perhaps those who are watching us and who are interested in a career as a human rights lawyer don't know enough about this extra courts case kind of work that you've been doing. So perhaps you could talk a bit more about this. I think, if I'm not mistaken, you've been involved in advising Commonwealth countries which are adopting anti-slavery laws. And you also won a really prestigious prize by the Obama administration in the US. So could you say a bit about these 2 lines of your work?
Certainly, thank you. So when I became a law student, I was interested in things going on in the world around me. You know, it was during the 80s, early 90s, as a teenager and as a young person in my 20s, the Berlin Wall was falling, apartheid was still ongoing. And I just always had this very great interest in what was happening in the world, but these things made me feel very sad. And I wondered always, like, am I always just going to feel sad? How is that going to be? Like, I felt like some kind of responsibility, but I didn't understand it. And then I went and studied actually at the International Institute of Human Rights in Strasbourg in 1993, which is the world's leading human rights educational seat of learning. It was established by René Cassin in 1969, who had drafted the Universal Declaration on Human Rights with Eleanor Roosevelt in 1948, and they'd won the Nobel Peace Prize. And with his share of the money, he set up this seat for educational learning in Strasbourg in France. So I ended up there quite randomly, you know, just a law student interested in world matters out beyond the UK, and met some of the most incredibly interesting and devoted people in the field of human rights, and listened to some of the world's leading experts. And it just struck me in my heart that human rights law is something that's very important to me. And so I then really just set about my own ambition that I wanted to learn more. So I did a lot of internships. I did an internship at the European Commission for Human Rights at that time in Strasbourg. That was the filter system of the court in those days in 1996. I did 1997, I was at UNHCR in London doing an internship on refugee rights. By 1999, I'd become a barrister, but I didn't know I was going to get my full-time job. So I had applied to go to the War Crimes Tribunal in The Hague. And I ended up getting both. And so I took the barrister's job in Britain, but I went off for 3 months to The Hague and I worked in the Office of the Prosecutor on the case of General Tiomir Blaskic. And during that time, I was asked if I could look at the question of witness anonymity, because witnesses were very terrified of giving their evidence before the War Crimes Tribunal against such violent people as those named in the indictments, but there was no possibility of witness anonymity. And yet I'd come from Strasbourg, where I'd learned a lot about human rights. And in fact, I won the world's leading prize in 1994 on human rights, the diploma of the International Institute of Human Rights. So The Hague just said, you know, can you apply your mind to this problem? So I drafted an application for witness anonymity, and 2 applications had failed before the chambers of the tribunal, and mine won. Obviously, it wasn't in my name because I was a temporary person there, but those who were supervising me happily put it forward uncorrected, and it succeeded. And that very much established to me a number of things. Number one is that you always have to balance the rights of the victims as well as prosecuting offenders, because otherwise you're not going to be able to prosecute successfully unless you protect and respect victims. And secondly, that I had something that was driving me in this field that I could create. So ultimately, when I came to start doing modern slavery, human trafficking work, by then it was 2003, been a barrister for 7 years. I then kept seeing gaps in the law, so I kept bringing lots of different cases, which ultimately led to me winning the Trafficking in Persons Hero Award from the US in 2015. But in the meantime, I was also doing advisory work and as a group of experts for UN Council of Europe, OSCE, and publications. And then by 2017, the British Parliament approached me and said, look, you brought so many cases against the British government in your career successfully, and you've really been responsible for shaping the development of the laws on human trafficking in the UK and abroad. And that's been well seen now by the Trafficking in Persons Hero Award statement. What about you come to us as the British Parliament? We're neutral, politically neutral, and you help Commonwealth states amend or improve their laws on modern slavery. So I just thought this was such an interesting opportunity. So I've been doing that for the last 4 years. For the last 3 years, I've been working on a particular project with the Commonwealth Parliamentary Association UK, CPA UK, and Uganda on an anti-slavery bill, which is currently going through their parliament. And it contains a few world firsts. It contains the world's first provisions to actually criminalize recruitment companies for actually deceiving people and recruiting them to take them abroad for forms of exploitation. Corporate liability is there. So not just we're talking about transparency in supply chains, it's irrelevant to the actual liability of a company or a corporation for human trafficking. And we want to see big fines, we want to see corporations brought to their knees, we want to see compensation for victims, we want to see protection strategies, prevention strategies, etc. So yeah, my work for CPA UK goes far beyond Uganda, and it's been a true privilege to be involved in that. And then actually one of the recent projects I've been involved in is with Lumos. Now Lumos is J.K. Rowling's children's foundation, and they approached me with some work a couple of years ago, which we're now finishing, and that is called orphanage trafficking. Now, across the world, wherever there's a humanitarian disaster, what we were seeing, and not myself, because I came into this new 2 years ago, but those who are specialists in the field, was that there was suddenly a proliferation of orphanages in those places. Like Nepal, for example, there was an 85% increase in the number of orphanages in Kathmandu after the earthquake a number of years ago. And it wasn't an 85% increase in the number of orphans, but criminals were working out that if they set up orphanages and they take vulnerable children, place them in there, then they can acquire international funding and funding from private donors, pretending that the money is going for the care and the humanitarian protection of children, when actually it's only designed to go into their own pockets. And no trafficking laws are actually dealing with this properly. Now, there's a brilliant Australian lawyer called Kate Van Dor, who's been at the forefront of this and is a wonderful, wonderful colleague. And so my side of it is that Lumos came to me and asked me, can I draft a model law against orphanage trafficking that can be used as a blueprint for all states that are affected by this type of criminality? And so that's what I've been doing. We are completing it in the next couple of weeks. I think it's going to be launched in the autumn, and this will have a very, very big impact, hopefully, on bringing down this pernicious trade.
Incredibly interesting. Now we are approaching the end of our interview, unfortunately, but I would like to now ask a final question about academia, because you've had this amazing practical experience in human rights law that you have just told us about. So incredible breadth and depth of like practical work in this area of human rights law. And now, since 3 years, we have had the luck to have you as our professor of practice in modern slavery. So I was wondering whether you can tell us a bit about this newer role that you are doing, like whether you've been enjoying it, what are the highs and the lows of your academic experience after such like an incredible career, which you continue to do alongside academia in professional practice?
Oh, that's a very nice question. So for me, the absolute jewel in my crown of my career was to have been invited to take up Professor of Practice in Modern Slavery Law at King's College London. The very luminary leadership of Gillian Douglas, the previous dean, was behind that decision. And it was wonderful to have been recognised for the work that I've done in the practical field of the protection of victims, to have something to contribute towards the academic life of the students at King's College London. So I was given my own LLM course, which is a module on the LLM, which I teach for 1 term. And I create the syllabus. A lot of it is about the different cases that I've brought and the different topics that I've discussed today and elsewhere. And it is just life affirming to meet students who are so keen to take on the baton and to take themselves into the position of learning enough that they can go forward and become leaders in this field. And that is something that I could only have experienced in this role at King's as Professor of Practice. So the highlights are every year meeting the new students, understanding from them why they're interested in this course, and then finding every single week that they're more and more engrossed in the cases and more engaged, and they all are very, very eloquent, and they speak at every single lecture we have. It's very discursive context. And then when they go and write their exam papers at the end of the module, I'm just always quite stunned by the excellence and the brilliance and their creativity. And so I feel like I'm just a stepping stone now for them, that, you know, if I can give everything that I've learned and I can show my insights, and what I always say to my students is like, let's hold the paper up to the light and see the gaps. And that's where your role will come in. Like, don't all come to me and then change your, pattern and want to be a human rights lawyer. But if you're interested in commerce or industry or shipping or housing or family law or technology, then use your interest in this field to bring it to the top of the area in your particular field, so that we can all work together. The downside, hilariously, is I find marking exam papers very time consuming. As I'm sure things have been a bit frustrated once or twice. But yeah, I literally read every single word. I think about it, I come back to it. And I think that's because as a lawyer, we are so forensic about every single word when we write it. It's going to go before a court, that I can't help but be as forensic about what each student writes for me. And so it doesn't matter how many years I keep doing this, it still takes me like 10 times longer than I think.
I think one or two people will agree with you on the frustrations of marking, but I think the privilege of our students to have you with such a deep practical experience in this most important of human rights law fields is really great, and we are really glad to have you as part of our team. Parosha.
My pleasure. Thank you so much, Octavio.